whatever weak acid, but it substitutes the chloro, Cl minus into the solution. Doesn't it that ends up to a chloride acid, which is a strong acid?
Cl minus is a weaker base than H3, so that's in the favorable direction actually. It's the other way you want to go.
Yeah, so that's the point. I'm quite confused. So it's like, when do I think the chloro minus has a weak base or like a strong acid, a part of strong acid? Like, how do we judge this? Like,
can we come back to that after block 5?
Right.
Because we're going to do acids and you're going to do acids and bases in block 5. It's just one of those things. It's like it's really hard to work out what order to teach some of this in.
Yeah.
Because it all overlaps a little bit.
Right.
It's too hard on the students to do the reaction chemistry all at the end. It's not enough time to digest it before the exams. So, but generally speaking, if you're replacing, if you're a nucleophile, there's a better base than your leaving group. That tends to be a favourable base. Yes.
Right.
Yeah. And amine, even though it's neutral, is actually a better base.
Yeah, I see that. And the last question is like, for next week's test, revision, is this part all in the test?
No, only to the end of block 3. Only to the before the next room.
Okay, and it's the same stuff in the assignment, the test that you find assignment. Okay.
Let's do this outside. Whatever you're doing.
Thank you, miss.
got sound. Kia ora koutou. Afternoon, everyone. This is Ivani. She's going to talk to you for a moment about why you should vote for her for AULSS. I'm about to put on the screen a QR code. I'm just getting my own slides up. So, Ivani, take it away.
Do I speak in there? Yeah. Will it work?
Yes, it will work.
Okay.
There.
Oh, yeah, okay. Good afternoon, everyone. My name's Ivani Tak. I was just letting you guys know that the voting for the AULSS elections are currently open. They close tonight at 6 p.m, and I'm here to convince you why you should vote for me. I'm currently a second-year student, juggling all 5 papers, which is actually really hard. I'm running for competitions officer this year because I think that I would like to make competitions less scary and a lot more fun. I believe competitions aren't just about winning, they're about building confidence, skills, and even friendships. I want to encourage more students to get involved because everybody deserves the chance to discover the satisfaction of pulling out an argument of thin air and making it sound convincing. Vote for me and I'll try and make competitions more fun and encouraging to get students involved and pushing their limits. Thank you.
And voila, appearing on the screen you have a QR code, so if you want to vote for Ivani you can do that now, or I can put it up on canvas. Sorry, I might just mangle this thing to make it more accessible. Okay, can I just check? I've got everything on full volume, but can I just check you can actually hear me at the back? Cool, thanks so much. Okay, so you've got me for the next 5 weeks. For the first week today, we're going to be finishing off defences, looking at compulsion and necessity. So you started defences with Kate, looking at self-defence. From there, we moved to property, looking at theft and theft in a special relationship, and a few others. And finally, we'll finish off with the last topic of parties for 2 weeks. And then Kate will come back in and do revision with you. Okay, so we are very, very much on the home stretch. I was expecting a little bit more than just a single whoa from Lisa there. Yeah. I did do an announcement yesterday about the exam, but I'm going to cover that now as well, because I'm told that you tend to pay much more attention to these things if they're done in a lecture. Before I do that, though, I do just want to repeat what I put in my announcement before we started back, how incredibly proud I was of all of you during the course of the sentencing assessment, the oral sentencing assessment. And I do sometimes roam the halls while you're standing out there looking nervous, and I also judged a huge number of them during the course of the week and also over the break here in the extensions. I know that when I give you this assessment at the beginning of the year that many of you think, how on earth can they possibly expect us to deliver this, and yet you all just have. Okay, I think that's an enormous achievement and one that I see students achieve every single year, but that nevertheless doesn't take away from the hard work that you put in and actually the enormous progress that you make over the course of the year in standing up and doing a plea in mitigation that really could be heard in the High Court without anyone raising an eyebrow. So well done to you, and I do, won't say too much more because I actually do I'm so proud of you that I do get a little bit emotional about it, but it really is a big thing for me to see the growth that I see in you. And I said at the beginning of the year how much I love looking up at your faces and seeing the progression that I'm going to witness throughout the year, and that is one really good example of that. So well done to all of you. I hope you enjoyed the fact that you had achieved it and you did actually really appreciate what you had actually, what you had done. And you're like, okay, great, but now she's giving us the exam details. Excellent. Okay, one achievement done, now on to the next. So your final exam is 50%, so obviously a fair chunk. It is open book. I'm sure some of you will be relieved to hear that. It is in exam mode D. In the announcement, I've given you the link to the information about that, so it's exam mode D on Inspira. And it will be 2 hours long. Okay, you do get 30 minutes for reading time and to deal with any technical problems that might arise with Inspira in that time as well. Okay, if you have no problems, then obviously you've got all that time to start writing. You can use that 30 minutes to write. You can start immediately. All right. The exam is made up of 3 questions. You must answer question 1. It is compulsory. And then you have a choice of answering either question 2 or 3. If you do not answer question 1, the compulsory question, and you answer questions 2 and 3, we will only mark one of those, and therefore that will be the only part of the paper that contributes towards your end of year mark. Okay, so please make sure you follow those instructions. All of semester 1 and 2 material is potentially examinable, except for homicide and sentencing. Okay, but remember that a lot of what we teach you in semester 1 are your foundational principles, and we build on those. Okay? Any questions arising out of that? Just something else I want to affirm. Exam mode D means you are on lockdown browser. So what that means is that you can take in anything with you. You can take in the textbook if you want. You can take in handwritten notes. You can take in printed notes. But you may not take in another device, and you will not have access to notes on your own computer. So that means you cannot cut and paste from your notes. You must create answers from scratch. Okay? No questions? No, just one. Not quite the same chairs that I had previously. All right, let's get into our topic today then. So we are looking at compulsion and necessity, where we are continuing on. That's right, just checking everything's working. Continuing on with the defences. You'll remember with Kate last semester, half semester, you were looking at the defence of self-defence. Self-defence is a situation where someone is confronted by a threat of some kind and they respond to that. Okay, it is called a justificatory offence, so you're justified in the way that you behave, and it's a complete defence. Today we're looking at compulsion and necessity, which are slightly different. This is when we don't say that the way in which the person has behaved is justified. We are excusing their behaviour. So what they did was still wrongful, but we are excusing it because they have behaved in certain situations. And the defences of compulsion and necessity means that we excuse them because we accept that the person is acting under duress. And the difference really between the defences are where that duress is coming from. Is it coming from a person? Is it coming from a circumstance? Is that circumstance an emergency circumstance? So for that reason, we have to consider where is the duress coming from, and that's why we divide it up into different types of defences. The first one we're going to look at and probably spend the most time on is the defence of compulsion. Now that is codified in section 24. It's sometimes called duress by threats. Now that should give you a pretty good idea of what it's all about. It's a threat by a person. Okay, so someone is saying, if you don't commit this offence, I'm going to kill you. Okay? So it must come from a person. Obviously, we're going to examine these in much greater detail, but I'm just giving you an overview of the topic. If the duress is coming from a circumstance as opposed to a person, then we call that duress of circumstances, or sometimes called defence of necessity. It is not codified. It's found in the common law, means it's a bit messier. And really this is about someone who is having to choose to commit a criminal offence because of the circumstances that they find themselves in, and so they're having to make a choice between what might be a worse consequence and committing the offence, which is a lesser consequence. I find someone, I come home, I find that my child has got a burst appendix, I can't get the ambulance there, I put my child in the car, I drive like a mad thing to the hospital, I go through red lights, etc. I don't want my child to die. Okay, I'm breaking the law by driving too fast and running through red lights, but it's the circumstances. Okay? The final one, don't tend to see it very often, is called necessity proper. We don't even necessarily admit in New Zealand that it exists, or there's some dispute as to whether it really genuinely still exists. And it's really where you're looking at a situation where you've got circumstances creating duress, but they're not necessarily circumstances of an emergency. Probably the easiest way to understand this particular defence is when you're looking at, so where you've got conjoined twins and you're having to make a decision about whether or not to operate, and the possibility that if you do, that one of the twins might die, but if you don't operate, they both might die. It's usually the sort of circumstance that we consider to be in the necessity proper bracket. It doesn't arise very often. So turning first to compulsion, okay, so this is our duress by threats. This is coming from a person. Now I'm going to, as Kate did, go through the rationale for the defence. And the reason for that is because if you understand the rationale for the defence, you'll understand why the law is interpreted in the way that it is. Okay, so if you've got an understanding of the rationale, that will help you when you come to apply the law to the facts if you bear that rationale in mind. So it's a general defence. It doesn't necessarily apply to any particular offence. It's not attached to any particular offence, but you'll see when we examine it a bit further that it's not available for the more serious offences. You can't kill someone as a defence to murder. Sorry, you can't say that you can't murder someone and then use compulsion as a defence because it is excluded by section 24. Okay, so you can't say, well, I was threatened and I had to commit this offence for the very, very serious offences. If you succeed in the defence of compulsion, you're going to see that it succeeds very rarely. It's a complete acquittal, so it's a complete defence. So the essence of it is, obviously in the words, compulsion, duress by threats, right? You are compelled to do something. So the basic idea of it is that someone is standing over you saying, do this or else. Okay, and if you bear that in mind, it will help you as we go through, because whilst it sounds simple, it starts to get a bit more complex when you apply it. And the idea is that your free will or your choice to do something is overborne by this threat from another person. Now, for those of you that might be thinking back to coercion in terms of sentencing, this is very different to the mitigating circumstance of coercion in a sentencing context. Okay, this has a much stricter set of requirements to it and is completely different to what you would understand coercion to be as a mitigating circumstance. So don't confuse those two. Okay, put the idea of coercion in a sentencing context completely out of your minds. Right, the rationale, and again, keep this in your minds, is that if you are faced with a threat, and this is coming from the leading case of Takuman, which is a very old case, as you'll see. If you're faced with the threat of immediate death or grievous bodily harm, GBH, then you are excused from choosing a lesser evil. Now note that we're talking about the threat of death or grievous bodily harm, so it's really, really serious harm or death that you are threatened with, right? GBH, you've learnt with Kate, serious harm, actual bodily harm is not enough. But your rationale has also been interfered with by the courts in the sense that they're saying, well, this is the rationale for it, but also we expect people to show firmness of character. This is coming from Justice Willie Young, who I suspect has never been faced with any situation of compulsion in his entire life. Firmness of character, and seek the assistance of the authorities or do whatever else is practicable. So a high level of coerciveness and the absence of any reasonable alternative to compliance is part of the rationale. So this is the court showing, in more recent times, this is a Supreme Court decision, the rationale also includes the idea that we expect there to be absolutely no other alternative, and people are expected to take any sort of avenue that might be available to them to avoid having to carry out the offence that they are being demanded or they are being asked to do. And you'll see this very conservative approach coming through in all of the cases. As I said, it's codified, Section 24, so even though it originates in the common law, Section 24 codifies it. Again, it talks about threat of death, grievous bodily harm, and the person must commit the offence under compulsion. Okay, so that inherently implies that there must be a threat and a demand. So when we start to examine the elements of this and break this down, you'll see how strictly those elements are actually applied in the context of facts. Now, the Supreme Court in Akalui have also made it clear that this is a complete codification of the common law. No aspect of the common law is left after Section 24 codified this particular defence, and that becomes important when you start to see how much falls through the cracks, how many of these cases fall through the cracks between self-defence, compulsion, where the threat is coming from a person but there's no demand attached to it. Part of the reason for that is because the person who's impacted by it is usually innocent, and just also the courts are wanting to avoid the idea that, well, you can get out of doing this because you're saying you were threatened. Okay, so again, it comes back to that rationale idea. And this is also the courts picking up and establishing again, and I'm sure you're thinking, why is she continually going on about this? But I want you to really understand this is a very conservative defence. Unlike self-defence, this is very, very conservatively and very strictly applied. So they are more likely to tighten the use of this defence than they are to be liberal about it. Where you cannot use compulsion as a defence is set out in section 24.2. So these are the offences where compulsion is not available to you as a defence. So obviously quite serious offences there. What you might note is that the more serious offence, sexual offending and drug offending, is not included in there. Now, why that is, I don't know. Okay, but it is a noteworthy omission. So let's look at how it works. Now, Taikoman, as I said, the leading case, set out the elements. There must be an existence of a threat to kill or cause GBH, and of course that is made very clear in section 24. And that threat must be to kill or cause GBH immediately upon a refusal to comply. If you do not do this, I am going to cause you really serious harm or kill you immediately. Now, obviously, 2 and 3 tie in together. You can only do that immediately if the threatener is present. And they must be present during the commission of the offence. Otherwise, the person has the option of not committing the offence. If they are not there during the commission of the offence, if they've left before the offence occurs, then obviously come back to the rationale. The idea is that the person will have an option to go and seek assistance from the authorities. Now, those first 3 elements of the defence are objective. Okay, so and we'll have a look at what happens in the case of mistake in a minute. And as I said, they're strictly applied. The 4th element of the accused must commit the offence in the belief that the threat will be carried out immediately is a subjective element. Okay, if the person can show that they genuinely believed that the person would carry out the threat, that will be enough. But you'll see that the courts have tried to make inroads even into that element. There's also an additional requirement that the person must not be a party to an association or conspiracy. It's contained within the words of section 24, and you can understand the rationale behind that. You can't join a gang and then carry out an offence and say, oh, well, I was threatened that if I didn't do it, they would kill me. Otherwise, we would see this defence being used much more often. So that is also included in there. Now, when does this become a live issue? So if evidence arises in the course of a trial, now whether it comes in from the Crown or comes in from the defence, it doesn't matter. If evidence comes in that suggests that this is a live issue in the sense that there is a credible or plausible narrative where the jury might say, oh, well, this person was threatened with GBH or death, that was accompanied by a demand, the person was capable of carrying it out. So really we're looking at the first three elements. Then it becomes a live issue and the burden falls on the Crown. Judge makes the decision about that. The burden falls on the Crown to then show beyond a reasonable doubt that the defence cannot be proven, i.e. that the person was not acting under compulsion. Horrendous if your defence counsel and your client hasn't told you that they were threatened and that's why they did it, and then suddenly you've got a Crown witness who's saying, oh, I told him that if he didn't do it, I was going to kill him. And suddenly it's all on. Never happened to me, but I have heard it happening. But once it's a live issue, the judge says, yep, there's a plausible narrative here. Right, Crown counsel, now you've got to try and disprove that they weren't acting under compulsion. So there you're really then trying to establish that the person didn't have a genuine belief. Okay? So let's have a look at our elements now. As I said, the first element is objective. Now, there must be an actual threat in fact. And I'm going to deal with this a little bit more in detail shortly, particularly in relation to mistake. And because the way in which Section 24 is set out, the threat must be accompanied by a demand. It's inherent in the idea of compulsion. Acted under compulsion, okay, there must be a demand with the threat. Demand must be aimed at forcing the defendant to commit the offence. Okay, and that's also been affirmed by a number of the decisions, Taikuman being one. As I said earlier, the threat must be to kill or cause GBH. Actual bodily harm is not enough. And that is very, very strictly applied. Now, I'm going to give you a case here as an example. Sorry, that should be a 2001, not 2011 there for the Māori Rere case. I'll change that when I put the slides back up. So that's 2001 NZAR 431. Down here. I'm not sure I have editing rights. No, I don't. Okay. Now, in that case, the defendant was charged with driving with excess breath alcohol, and she sought to rely on the defence of compulsion under Section 24. Now, on her evidence, which was not challenged in cross-examination, so the evidence was accepted as being genuine, she said she'd been compelled to drive by her partner, who had hit her in the face repeatedly and was continuing to assault her, told her to drive this fucking car, otherwise I'll smash you and the car up. Now, there was evidence adduced that previously he had blackened her eyes on numerous occasions, dragged her out of the car by her hair, kicked her in the head. I think from memory he may even have thrown a bicycle at her. But the defence was withdrawn, so the judge withdrew the defence from the jury on the basis that there was insufficient evidence to support the defence, because it didn't reach the evidential burden. So it wasn't a live issue, on the basis that the level of harm did not reach the required level of harm of grievous bodily harm. So we had a threat accompanied by a demand, but the threat did not reach the required standard of GBH. Okay, so that gives you a pretty good example of how strictly applied this is. So if you think about that from a practical point of view, which for most of us, I hope, fortunately, is only a hypothetical situation, but really what this case suggests is that a woman is, if she wants to rely on the defence of compulsion, not that I'm sure she's thinking about that at the time, has to wait until the level of harm that she is threatened with or that she is being subjected to has reached a sufficient level of violence that she then can rely on the defence. So if you come back to Justice Willie Young's comment, firmness of character, it starts to show you just how unrealistic the way in which this law is being applied is in the context of real life situations. Now, in addition to that, the required threat may be either expressed or implied by words or by threatening gestures. And in the case of Taiaroa, this was in the case of a prison riot. Now, in that case, there was a lot going on, and the court in that instance said that with the level of harm that was being caused and the gestures that were happening, that the person who was seeking to rely on the defence of compulsion was able to do so because of what was happening expressly and subtly in terms of the behaviour such that GBH was the level of threat implied in the conduct. Okay, so would seem to suggest a bit of a lack of consistency there. And there must be a specific threat. So if you are just merely frightened of someone, that is not enough. And that is established in the case of Rauroa, which I'll talk about in a minute, because in my view it's quite an extraordinary case. And you'll see, again, just how strict this defence is. Now, what if you're mistaken? Okay, what if you're mistaken as to the threat or the level of threat? So you remember this is objective. Now, some academics have talked about there's a distinction between a threat that you genuinely believed existed but didn't actually exist but you misheard, for example. I mean, you still genuinely believe in the threat and the level of threat. And perhaps someone who has overreacted or has exaggerated the threat that they think they're facing. The suggestion being that in the case where you think there's a genuine level of threat, you genuinely think the person is threatened to kill you, but you have, say, for example, misheard that, and then you go in and do it, then you should still be able to rely on the defence, because in terms of the rationale, you are still acting under compulsion as a result of a threat of death. The court have said no. Whether there is a relevant threat is a matter of fact, so a mistaken belief in the existence of the threat is not sufficient, even if the mistaken belief is reasonable. there must be a threat in fact. Now you can imagine, how is this evidence going to be adduced? Oh yes, I'm going to get up in court and say, yes, I did actually make that threat, yes, I did. You know, and when we look at this Rarawa case, you'll see the impossibility of actually trying to adduce evidence in these situations. So in that case, so the accused, I'm going to give you a few facts here. You don't necessarily have to write all this down, but I think it's worthwhile just actually being aware of the scenario that this guy found himself in to get an understanding of the situation that he was in. And I can imagine you can, well, I'm hoping that you can see where this ends up, where they say the defence of compulsion is not available to you because there was no threat or no demand with the threat. So this guy was charged with being an accessory after the fact, with assisting two guys with moving the bodies of two victims who had been executed by the two men for narking. Now, this is a 1987 case, it's a wee while ago. And prior to the two men being executed for narking, Mr. Rarawa's wife had been told they were going to be taken away to be shot. And she had told him, and he didn't believe that it was going to happen. Okay, they then turned back up at his place after they had killed them, with 3 empty cartridge cases, and said they'd wasted the victims for narking, and anyone else who narked would end up the same way. And I would have thought that's a pretty clear threat. They then went away and later contacted Mr. Rarawa's wife, asking that he then assist them to dispose of the bodies. Now, bearing in mind, of course, come back to your rationale, they went away. Okay, so you've got, if you say that you've maybe got a threat here, you've then got a demand sometime later, and in between they have left. Okay? So at this point, Mr. Rarawa realises that the guys have in fact been shot, and he starts to become very afraid. So he gets a knife for his own protection, and he gets in the van with these guys, and even though the court accepted that, even though he was very frightened, and that the gun that the men had when he was in the van was loaded, they said the accused was no doubt very frightened of what had happened, and frightened of what he would see, and frightened at the men who could have done such a thing. But then went on to say, and the words are up on the slide, "It is true that a threat need not be in words, but it must be a particular kind of threat associated with a particular demand." There was no evidence that either Williams or Pope, being the two guys who had killed the narcs, had made a demand of the applicant to assist with the disposal of the bodies, coupled with a threat that if he did not do so, his immediate death or grievous bodily harm would result. Now let's imagine how that might go down. He's sitting in the back of the van, they've got a loaded gun, he knows that two guys have just been shot for narking. To be able to rely on this, he would have to say, "Oh yeah, hey guys, look, can I just check out here what's going to happen, what's going down? So if I don't do this, are you going to kill me or, cause me grievous bodily harm, just so I can check here?" It's just not practical, right? So you can see in the context of real life cases, sorry, I don't have a very good sort of gangster voice or whatever you want to call it. But you can see in the context of real-life cases how impractical this might be in trying to establish the elements from an objective point of view. Now, the court also put great stock in the fact that, I might add, that he had, when he was first apprehended by the police, he didn't say, they made me do it. Right? So, in that sense, they also thought that if he'd said that, then maybe that would have assisted him. I'm not sure that it would have, but nevertheless. Now, many academics have criticised the very strict nature in which this defence has obviously been applied, on the basis that if you're acting under compulsion, whether the strict requirements of the defence are met or not, the fact of the matter is you're still acting under compulsion. You are still carrying out something under the threat of grievous bodily harm or death. Now, obviously you've got this fourth element of whether or not you had a genuine belief, and that would weed out any situation where there wasn't a genuine belief in threat, and the threat of death or grievous bodily harm if you didn't do what you were being asked to do, or thought you were being asked to do. But the court aren't prepared to allow that. Is it sufficient that if the threat is to someone else, can you rely on it? It's not really been made clear. We haven't really had a case that's come up where the court have said, other than an obiter, that they would allow that, but it would seem to be that in the case of Neho, where the court said if where the accused children were threatened, then they would have considered that that sufficed. The defence failed on other grounds, but certainly that leaves the door open to the possibility. My understanding is that in England, and I would need to check this again as to whether or not it's changed, but my understanding is that a threat to someone else, I think, is not permitted. Don't quote me on that. I might just take the break there before I moved on to the second element. It seems to be a good place to stop. Start again at 3. Yep, great.
I assume it. Yeah.
God, I hate PCs. I use an Apple, and it's a nightmare.
It's okay if it doesn't work. That's all right.
That's right. It's just everything's backward.
I can try as well. Oh, perfect. Yeah, that's the same thing. So that's just the loading as well. All right. Thanks so much. Oh, I'm Hamish McKelvey. Awesome, thanks. Perfect. Really appreciate that. That's so good. Should I just sit in the front row or something and then come up? Okay. Yeah, I'll just be like 10 seconds. Yes.
So Hamish is just going to also do a quick promotional talk as well about why you should vote for him.
Hey everyone, just a really quick note. I'm running for sports officer of AULSS. I've been super involved with the Law School Run Club, which is like the main thing the sports officer does. So definitely do the same thing, follow the link and vote for me. It shouldn't take long at all. and I'll definitely try and organise some fun events and sponsorships. Thanks.
Okay, let's get back into it then. So, our next element is the immediacy of the threat. So the threat with the demand must be able to be carried out immediately. So it's the idea of then and there. Okay, there's no other option for you to do anything other than carry out the offence because the person is there and going to carry out the threat immediately. All right. So this idea of immediacy is a really important part, and it ties in, obviously, as I said earlier, with the third element about the threatener being present. And it's about the idea of inevitability, okay, which I think is an interesting point in terms of, referred to back in Entitlement, which is an old case, given, as you'll see when we go on, when we look at the way in which the Law Commission is suggesting some reform in this area. The idea of inevitability is important, but yet the courts will not pick that up when looking at situations involving intimate partner violence. Now, there's some suggestion from the courts that there might be a little bit of flexibility here, and this was particularly suggested in the Neho case in Obita, where the person it was made clear to them that they would be taken somewhere else by the person's associates and the threat would be carried out there, and the court were prepared to consider the possibility that that might suffice. As I said, the defence did fail on other grounds. But if the threatener actually left at any time, then that immediacy is gone. Okay, so there's some flexibility there in that if you don't do this, I'm going to cut your throat, but obviously that can't happen in the bank. Okay, then there's some flexibility in terms of time, but not much. In terms of our third element, as I said, it's quite tied into the immediacy point. In terms of presence, obviously you can't carry out the threat immediately if you're not present. The old version of the section used to say actually present. They removed the word actually, but said it made no difference whatsoever. But various academics have said, well, actually does make a difference, because it actually requires the person to be present, in fact, at the time and place, whereas present can be sensibly understood as including not only a person who is in the immediate physical proximity, but also close or near to it. But the courts have not accepted that. They've said there's no difference whatsoever. In terms of the opportunity to seek assistance, Justice Willie Young, again in Akalui, stated that the requirements for presence and immediacy reflect a legislative purpose, that if there's sufficient time to seek assistance from the authorities, the defence must fail, even if the person has a belief, reasonable or otherwise, that no assistance will be forthcoming. So, if you have an opportunity to seek assistance, even if you know that assistance isn't actually going to help and that is a reasonable thing to believe, if you don't seek the assistance, then the defence is not available to you. So you can imagine that that might arise in the context of intimate partner violence. So you'd be saying there's a common theme here where those are really the cases that are falling through the cracks between self-defence and compulsion, where there's really not much in the way of a defence available to women who are faced with ongoing serious violence where the threat is present at all times. But unless there is a present threat accompanied by a demand, they can't rely on these defences. There have been various attempts to widen the concept of presence, but they haven't been successful. Various examples in cases like, as you will have come across earlier in the year, Kuka and Whitaker, the idea that you are under a constant threat of violence yourself, which is why you didn't seek help for your child, has not been accepted. In terms of presence of associates, as I said earlier in Neho, they said if the associates are there, even if it's not the threatener themselves, then that will be considered sufficient as presence in terms of obiter. But if the threatener leaves at any time, even if for a short amount of time, the idea of presence is broken. Now that obviously can be an issue where you've got a continuing offence. Now say, for example, the gang next door says, we want to use your house to manufacture pee in your basement. They set up their pee lab and they say, if you don't allow us to do this, we're going to kill you and your family. Okay, the minute they leave, that threat, whilst it might have been immediate, the minute they leave, there's no presence, you wouldn't be able to rely on compulsion for manufacture of methamphetamine. Okay, so where you've got a continuing offence, it really becomes a problem. And this is quite often also the case where you've got ongoing fraud, use of cheques, things like that. Used to be an issue back in the day when we had cheques. Now, this fourth element, which, as I said, is a subjective element, has made it clear there must be a causal link between the specific coercive threat and the offending itself. So if that can't be found, then the defence fails. So if you commit a different offence, then arguably you can't rely on the defence of compulsion. And if you've got a continuing offence, you've got to have a threat and a demand every single time, with presence every single time, and a belief that the threat will be carried out for it to be a genuine belief and show a causal connection. Now, there's nothing in the section to suggest that the belief needs to be reasonable. Okay, so there's no element of objectivity suggested here. an entitlement, which, to be fair, is some years old now, made it clear that that belief was a subjective element. However, the courts have nevertheless, even most recently in Hay, said or tried to inject in elements of objectivity, where they've said that actually this final element is a mixed subjective and objective test. So it need not be reasonable, but the reasonableness of the belief will be relevant to whether it's genuinely held. Can anyone tell me what the problem with that is? Aside from the fact that it's supposed to be a subjective test. Can anyone explain to me why that's not a true objective test? Is anyone able to point out where they've gone wrong here? The reasonableness of the belief will be relevant to whether the belief was genuinely held. Is that an objective test? No, why not? What's it actually about? You're going, oh goodness, really? It's Tuesday afternoon. Sorry, can you repeat that? I missed the first bit.
Making it about the reasonableness of the belief means that it being relevant to the genuine objectiveness of the belief means that it's basically just an objective test at that point?
Not quite. You're sort of hooking on to the right point, but if you think about the genuineness of the belief, when we talk about genuine belief, someone gives evidence and they go, well, I genuinely believed when this person who was paralysed from the neck down was going to shoot me, and we go, I don't believe you when you say that. Is that an objective approach that we're taking there, or is that just that we're saying your evidence is so ridiculous that I don't believe you? But that's not an objective test, that's just an evidential credibility witness point of view. So the court in saying this is a mixed subjective objective test is actually really just trying to say witness credibility is about objectivity, which is not the case at all. The genuineness of the belief is the subjective part. If you genuinely believe it, you satisfy the subjective aspect. If you can convince me when you say I genuinely believed it, then you satisfy the test. You satisfy the fourth element. But if your evidence is so unreasonable that I go, I don't believe you, that doesn't mean I'm imposing an objective aspect to the test. It means that I don't believe you. You're not a credible witness. Can you see the distinction? I'm getting some nods, not many. Does anyone want to explain that again? Okay, so a subjective test is saying if you can show me in your head that you genuinely believed this person is going to carry out this threat. I can't say, if I believe you when you say that, even though I think it's an unreasonable belief, if you genuinely held it, then because it's a subjective test, the test should be met. The element should be satisfied because it's a purely subjective test. Now, the court in Hay are trying to say there's an element of objectiveness here by saying if it's unreasonable, then that imposes an objective aspect to it. But if it's unreasonable, we think, well, it's so unreasonable, I don't believe you. That's not an objective aspect to the test. That is, your belief is not genuine, so when you give that evidence, I don't believe you, I think you're lying. Okay, that doesn't make it objective. It's not me saying objectively in those circumstances, I think you could not have believed that. I'm saying I just don't believe you. Okay, so the more unreasonable someone is, the more likely we are to think, I don't think you had a genuine belief. I think you're lying. I don't think that you subjectively actually believed that. But it's not actually an objective test. Okay, and we see this crossover all the time in the criminal law, where we talk about subjective elements, but we think about the genuineness of what the person is saying. And we think about whether or not, if it's reasonable, if it's so unreasonable that I don't think the evidence is credible, that's an evidential point of view. It doesn't change the substantive nature, the subjective nature of it. Okay? Hopefully you've understood the distinction. But what it shows is that the court are really trying to make inroads into this defence. Now, just that final point that if you're party to a conspiracy or some kind of an association, this normally arises with gangs, then you can't rely on the defence. Okay? And you can see from a policy point of view why that might be. There has been some suggestion that this area of the law should be reformed. And this was looked at in 2021, so quite recently. And the submissions all called for widespread reform, particularly in the area of coercive control and situations of ongoing intimate partner violence. Now, you might be interested to know, I was quite aggrieved when I discovered this, although part of me thinks that maybe this would be preferable to what we've got now. But in the common law, there used to be a presumption that as a wife, if you committed an offence jointly with your husband, then you were coerced. It was just that assumption, that you were coerced by your husband. You didn't have to worry. You didn't have to worry about relying on this. You were just being coerced by him. Right? They got rid of that. We're not all subject to our husband's control. But now we're left with this huge void where they've now, because they have codified the common law completely, where we've got elements of coercive control, intimate partner violence, that we've got this massive hole that women who are subjected to these situations have no law to rely upon to assist them. So despite the fact that all the submissions to the Law Commission actually suggested that there should be widespread reform, and they looked at the idea of, instead of the immediacy of the threat, that it should be replaced with inevitability. And you remember in the Teichelman comment, it talked about inevitability as being the basis of it. This is an inevitable threat and that is going to be carried out. In fact, the law went the other way, and they in fact tightened up, suggested that the law should be tightened up to add another element, that the threat must be one. The submissions to the Law Commission were all on that lines. The Law Commission then recommended that the law should be tightened up to include an additional element, that the threat must be one that in all the circumstances the defendant cannot reasonably be expected to resist. Okay, so they wanted to make it even harder to use compulsion. That didn't happen, but it just shows that the law is going in a different direction to the submissions that were provided to it. Now, duress of circumstance is much messier because it's in the common law, and therefore it's not quite so certain, and it doesn't arise quite so often. So we've talked about duress by threats from a person, and now we're looking at duress of circumstances. Ordinarily we were looking at emergency circumstances. Sometimes this is called defence of necessity. Okay, so this is the one I talked about at the beginning, where I'm racing to the hospital with my child in the back. Things like I break into someone's house because I'm caught in a snowstorm and I need to get out of the elements, are the sort of circumstances where you'll see this. It's not codified, but it is preserved by Section 20 as a common law defence. There is also, in addition to that, as I said earlier, the defence of necessity proper, which is not clear whether it still exists, but necessity proper tends to be one where you're not looking at an emergency situation. But again, there is both of these sit in tandem, but neither one of them are codified, they're both still protected by the common law. You're still looking at a scenario where you are choosing the lesser of two evils, but where you are not necessarily an emergency situation. So in terms of duress by circumstance, again, it's an accusatory defence. You are excused, your behaviour might be blameworthy, but we excuse it because of the circumstances that you find yourself in. If you can prove it, it is a complete defence. And it's a recognition that people have difficulty complying with the law in emergencies. Now, the main distinction that arises here is where the compulsion comes from circumstances rather than a person. Okay, and that's really what you're looking for in these factual scenarios. If the compulsion, the duress is coming from a person, then you must look at Section 24. If it's coming from a circumstance, then you are looking at the common law duress by circumstance or necessity. Just some examples here. And it would be interesting to know whether or not any of these defences are being run in court at the moment with the amount of people that I suspect are being charged with theft, given the level of poverty that we are starting to see out in our community. I recently was walking to work and I heard a guy being accused of theft in one of the shops in town, one of the sort of dairies, and I heard him say, "What do you want me to do? I'm starving, I have to eat." So, sorry. So yeah, we're certainly seeing a lot of this in our community at the moment. Whether anyone will succeed, I would think not, unfortunately. Now, the rationale for this is we will excuse someone for taking these steps because no one should be obliged to do something against their own self-preservation. But nevertheless, the level of harm which they must be facing and so the lesser evil that they must choose must be on some level proportionate. So again, we're coming back to this idea that where someone is faced with loss of their own life or really serious harm to themselves, then we excuse their behaviour. Now, this one didn't particularly get off to a great start in terms of its origins. So in the case of Queen and Dudley and Stevens, in fact it might even have been the King back then, a number of people got stuck in a boat. They were shipwrecked, I think. And in the boat was the cabin boy. And they ended up killing and eating him. And they claimed he was weak and likely to die anyway, and if they hadn't done it, they all would have perished. So they raised the defence of necessity, duress of circumstances. And the court rejected the defence on the basis of policy reasons. Why is your life more important than anyone else's? Okay, to allow it would have allowed or permitted people to prey on the weak. So you can't kill someone to save yourself. Okay, so you can imagine it wasn't a great start to the origins of this defence. And as a result, the defence has been allowed to sort of run along as a common law matter. We don't see many cases applying it or trying to use it, and those that do very often don't succeed. And they're not normally run in great circumstances either. Now, one of the more prominent cases, New Zealand cases, is the case of Attorney General Leeson. And this might be one that some of you older students will remember. So this was the case where 3 men entered the Waihopai Valley, damaging the satellite dome of the Government Communications Security Bureau, the GCSB, down in, I think, Invercargill. This was this massive big white dome, millions of dollars worth of damage. And they said they were motivated by a desire to expose and prevent the harm caused by the Second Iraqi War, which they believed the GCSB was contributing to by spying on the US, on behalf of the US and supplying information to the US. And that information was being used to possibly capture, and I think the allegation was that torture people. Right, so they were arguing that by trying to prevent that, they were basically justified or excused from the damage that they committed. Now this, I think, was, if you look at the case, they ran a number of defences. Self-defence was another one they ran. So really this was, I would suggest, a case where a lawyer has got hold of these, or has been briefed to appear for these guys. Massive case, was all over the media, and he went, or she went, how the hell am I going to find a defence here? And searched around for anything they could find that might be useful, with not a great deal of luck. right? Can I use this area of law in a way that it perhaps wasn't intended? Now, the court rejected the defence, as you might imagine, on the basis that they were unable to prove that the illegality had been proportionate to the peril involved, and the defendants had no way of knowing whether any imminent or immediate peril existed, or of knowing whether the damage they caused to the satellite dome would in fact impact the supposed peril. Okay, so they didn't accept the defence on any basis, and you most often see this defence being run in these process cases nowadays. There was a case run in the UK based on situation of hunger. Again, the courts did not accept over there, and I would say the same would apply here, where they did not consider that it excused the behaviour. It was really on the basis of sort of the floodgates argument, and they really left it at that. The idea that the courts must, for law and order, take a firm stand and hope that the distress of the hungry and homeless will be relieved by the charitable and the good, I think was perhaps a little hopeful, particularly in the current context. Now, it has started to emerge a little bit more in cases involving traffic offences, as you might imagine, given the scenario I gave you initially. Unusually prison escapes, and initially as rationale for illegal abortions, back when an abortion still sat within our criminal law. Nowadays we do, as I say, tend to see it more in protest, but it's still not really that clear as to how it works. Now, in the case of Kapi and the Ministry of Transport, they set out the elements of the defence, and they were more clearly defined in the case of Quinn and Hutchinson. And that case involved, from memory, a situation where a guy tried to damage some poison that was being distributed in the bush. The defence wasn't accepted there either, but the court at least helpfully set out the elements being a genuine belief formed on reasonable grounds of immediate peril of death or serious injury, circumstances in which the accused has no realistic choice but to break the law, and the breach of the law must be proportionate to the peril involved. Okay, so in the Leeson case, it wasn't proportionate. They couldn't establish reasonable grounds of imminent peril of death or serious injury. They also couldn't establish, really, in that case, that they had no realistic choice other than to break the law, so they failed on all bases. Now, there must also be a nexus between the imminent peril of death and the choice to respond to the threat by unlawful means. Okay, so again, you've got to have this nexus by saying, well, I did this because of this threat. Okay, so Hutchinson added this particular element by showing this nexus must exist, which I think brings it more in line with the concept of compulsion, which is appropriate, in the sense that the two are quite similar. Now, as I said, the limitation on the defence is that it must not be from a person. It must not be from a lawful decision. So if you decide, okay, I failed in the courts, which I think was the case in in the Hutchinson case. I'm going to take my own approach, and this is the way in which I'm going to respond. That is not sufficient to qualify as a threat in the context of relying upon duress of circumstance, and you can't rely on it for murder or attempted murder, okay, which makes sense. Right? You can't kill someone to protect yourself, other than, of course, in circumstances of self-defence. Now, where the threat comes from a circumstance and not a person, you would think that might be quite simple. But as Kate would have talked to you about in the case of police in Kawiti and in Hockingen Police, that means that defendants in those cases are only left to rely upon Section 24 or potentially self-defence. And this is because Section 24 completely codifies the law, which was made very clear in the case of Akalui. And where this most often arises is in your driving cases. Now, in the case of police in Kawiti, now tell me, did Kate go through the facts of this one? Does anyone remember? It was where a woman was out with her partner on the marae. He assaulted her, dislocated her shoulder. Ringing a bell? Nope, okay. So this woman was out on quite a long way out in a rural area on a marae. She was assaulted by her partner. He dislocated her shoulder. He was, I think from memory, drunk, and she had also been drinking in so much as that she was over the limit to drive. And she wasn't getting any support from the people around her, and she decided that the best thing to do would be to drive back into the closest place to try and get some assistance. So she drove to the hospital emergency department, and she asked them to call the police. Okay, now that seems to me to be quite a reasonable thing to do. I need to actually get someone to relocate my shoulder and help me and get myself out of a dangerous situation. What do you think happened? Yeah, police arrived and they arrested her for driving with excess breath alcohol, and she claimed that she relied on compulsion and she relied on duress of circumstance. Now, compulsion failed because there was no threat and there was no demand to drive, so that failed on those elements. And she couldn't rely on duress of circumstance because the court said the threat was coming from a person as opposed to your circumstance, and therefore you can't rely on duress of circumstance either. Okay, so there was no defence available to her. In Hockingen Police, which I'm pretty sure Kate would have mentioned as well. Yep, I'm seeing some nods. Again, the circumstances there were she tried to rely upon, I think from memory, she relied on self-defence and failed there because she was driving a car, I think, yeah. So she then also sought to rely on duress of circumstance, which again the court said failed because the threat was coming from a person as opposed to the circumstance. Okay, so again, there was no defence available to her. And the court in Akalue made it very clear, as I've said previously, that Section 24 completely codified all of the elements of the common law and left no part of the common law that still protected someone in these circumstances where the threat existed from a person, but they didn't meet the strict elements that are now codified in Section 24. Okay, so they removed all of the common law aspects of this defence, leaving this big gap, and have refused to budge from that position since. Now, there's been quite a lot of criticism of this on the basis that if someone is facing a threat, whether it be from a person or a circumstance, if they are acting out of fear, how does that change their behaviour? If you come back to the rationale, this person's will is overborne. They are choosing the lesser of two evils. I think I'm facing really serious harm here. My shoulder is dislocated. My partner is violent. There is no help for me here. I need to get somewhere safe. But I don't meet the requirements of the law, and therefore I'm going to have to break the law to save myself. So if you think about, do we really want to have our law that is saying, well, actually, yeah, sorry, bad luck. That's, we accept that you were fearful. We accept that you felt that you had no choice to try and protect yourself, but that's tough. Mr. Raroa, we accept that you're in the back of a van with a loaded gun, but actually, and you think these guys are going to kill you, but because you didn't actually ascertain from them that they were going to kill or cause you GBH, if you didn't do what they were asking you to do, then there's no protection for you. But our courts have been very firm in holding the line here. So when you come to look at this defence and applying it to a set of facts, for example, in an exam situation, remember the rationale for the defence. Remember how firm the courts have been in relation to how the defence is applied, both in terms of compulsion and duress of circumstances. And think about that when you are applying the law to the facts. If you're thinking, well, which way is this likely to go? Is this going to be considered to be a live issue where there's a plausible narrative on the facts such that the onus now falls on the Crown? Remember, this is very, very strictly applied. Now, another example where perhaps this goes the other way is the case of Freedom Police. So the defence failed But it was sort of a weird scenario here. Now, this was a case, I think, up in Whangare, where he was convicted of careless driving, so the court got out of this in a different way. So he had 5 angry men that for some reason had taken against him. They were kicking and hitting his car, and he believed that they were going to pull him out of his car and drag him and assault him. And he argued, and he then took off and went through an intersection, and he got charged with careless use. I think he hit someone. Yes, he did. He hit a car. Right, so he sought to rely upon defensive duress. Now, obviously the threat was coming from the people, so you might have thought that he couldn't rely on compulsion because there's no threat in demand. So the only one he had available to him was defensive duress of circumstances. But the defence failed because the charge, the basis of the charge was the fact that he pulled out into the intersection was an error of judgment on his part. And the court said, well, they didn't think he had reasonable grounds for believing he was in imminent peril of serious injury. He was safe in his car. So he's in his car, there's 5 people, banging on the car, smashing on the car, rocking the car. And he had realistic options for dealing with the threat other than breaking the law. And they didn't think that there was a nexus between his claimed duress and his offending because he just drove badly. Now, if you put yourself in that circumstance, you might think, well, this is a young guy who's obviously frightened. That seems ridiculous. But what is important about this particular case, and I suspect because the judge got it wrong, in the sense that he didn't perhaps understand and he left the door open inadvertently, but nevertheless, if I was defence counsel, I would be trying to leap through it. The judge did not reject the possibility of the defence on the basis that the threat stemmed from another person. Right, so you might have thought, okay, so he can't rely on compulsion because you've got no threat, no demand. Shouldn't be able to rely on duress of circumstance because the threat's coming from a person. But the judge didn't actually rely upon that, and that would have been the easier way to have rejected the defence. Okay, so perhaps inadvertently left the door open. I don't think it's likely to be an opportunity to run it, given we've got the Supreme Court saying very, very clearly it's codified, but it raises an interesting point. Okay, so there is case law which is not necessarily applying akalue in the strict way that it should be. Could be that the judge got it wrong. How are we doing for time? It does raise, for those of you that are interested in this area, it does raise some interesting points in terms of discrimination, in terms of the convention that we've signed up to on the elimination of all forms of discrimination against women, and obviously our Bill of Rights Act, if that's anyone's interested in looking at that as a topic, particularly if you're doing honours. Just closing off the last few points in the time left, as I said earlier, the defence is not available where the threat is a result of a lawful decision. So that was made very clear in the Hutchinson case, where he tried to ruin this poison that was found in a shed. And he had basically exercised all his rights under the law, and this is sort of what he had left, and that didn't give him a justification. It didn't pose a threat in the sense that he was trying to rely upon it. Again, Hutchinson was one of those cases where you could see the Defence Counsel going, how do I find somewhere in the law that is going to help me to run a defence here? So as I said earlier, it's not available for murder, and it's also not available for attempted murder. Now this, of course, raises some interesting issues when we're looking at conjoined twins. What is the situation where you are having to try and consider whether or not you should separate conjoined twins? When we delve down a little bit further into these elements, when we're looking at imminence, does it equate to immediacy in terms of the idea of compulsion? Or is it something different? Now, the courts have declined to actually be drawn on this point. So when I said the common law, it's messy, it's not clear. This is why I've given you the way in which it's sort of developed over time, so that when you come to have a look at these elements, you can see why it's not particularly clear. Okay, so our elements are really not that certain. We don't know. You've got to have imminent peril of death or serious injury, but what does imminent mean? Okay, and the courts, as I say, talk about there's no realistic alternative, but we've got very few cases which actually talk about what that means. You've got to have no realistic choice, no other means of diffusing the threat that you're facing of imminent peril. So if there's a realistic opportunity for you to diffuse the threat, even if it's a really expensive one, then you must do so. It's not clear whether this is an objective or a subjective question. If it is subjective, then it would have to be on reasonable grounds. It would have to be a genuine belief on reasonable grounds. Okay? And as I said earlier, this element of proportionality comes in. Now, this really is about sort of filling the gap that Section 24(2) fills with compulsion, where we've said, well, it's not available for these serious offences. Proportionality is filling that gap in the context of duress of circumstances. Okay, so again, we're asking the question of, well, what would the firmness of character idea, certain characteristics, a sober person of reasonable firmness sharing certain characteristics of the defendant would have responded in a like manner. Okay, so we're expecting someone to behave in a very rational, proportional, upstanding citizen kind of a way, where we balance the harms. So Julie Tommy talks about we should be balancing harms as opposed to thinking about whether or not the person's will is overborne, which is the basis of compulsion. And again, Hutchinson has produced this idea of a nexus. So you've got to have actually committed the offence because the immediate peril was acting on your mind at the time. Now, there's not many examples of this, and I'm just going to finish on this particular one. This was the case of a guy that saw some children getting themselves into danger near some rocks, and in trying to save them, and they weren't particularly enamoured with that idea, they were trying to fight him, and he was starting to lose his strength and his ability to keep himself afloat, let alone them. And he assaulted one of them to try and get them to comply so that he could get them to safety. It was accepted that he had acted in a situation of necessity, duress of circumstances, because otherwise they were all going to drown. Okay, it's one of the few cases. So it's a reasonably good example. Okay, I'm going to leave it there. I'll see you next week where we start property.